Good afternoon. Just because I always wanted to do this, I will do it. Excellencies, dear colleagues, ladies and gentlemen, a warm welcome to all of you here today. I'm pleased to open and honored to open Supplementary Human Dimension Meeting to discuss ways to promote freedom of expression, as well as the related rights, responsibilities, and OSCE commitments. Ever since I took office in 2010, free expression and the need to protect it has been the focus of activities. I'm glad that the Swiss chairmanship decided to dedicate today's event to this important topic. Before I give the floor to our esteemed speakers, I would like to take a minute to recall the advance of free media and free expression principles over the 39 years of the existence of this organization. Many of the commitments that our governments have anonymously adopted show how advanced the OSCE has been in identifying and addressing threats to free expression many years ago. Allow me to shortly mention only a few. It's always good to remind ourselves of the achievements and of all these wonderful documents that all states adopted voluntarily. In 1991, in Moscow, the participating states reaffirmed the right to freedom of expression, including the right to communication and the right of the media to collect, report, and disseminate information, news, and opinions. They further recognized that independent media are essential to a free and open society, and accountable systems of government and are of particular importance in safeguarding human rights and fundamental freedoms. They added that the public will enjoy similar freedom to receive and impart information and ideas without interference by public authority regardless of frontiers. At the Budapest Summit in 1994, the states reaffirmed that freedom of expression is a fundamental human right and a basic component of a democratic society. They committed themselves to take as their guiding principle that they will safeguard this right. In 1997, in Vienna, the participating states, recognizing the need to improve freedom of expression in their home countries, established the Office of the OSCE Representative on Freedom of the Media to observe relevant media developments in all participating states and advocate and promote full compliance with OSCE principles and commitments regarding freedom of expression and free media. In 2004, in Sofia, the countries agreed that the OSCE representative on freedom of the media will continue an active role in promoting both freedom of expression and access to the internet and will continue to observe relevant developments in all the participating states. At the Astana Summit in 2010, participating states valued the important role played by civil society and free media in helping us to ensure full respect for human rights, fundamental freedoms, and democracy. As you can see, we have a good and strong commitments, but where do we stand with their implementation? We can ask many questions, and I will do this as usual. All these words are wonderful words on paper. They are honorable, valuable words. But what do we do with those words? What the governments are doing with these words? Are they just taking the note, or are they trying to implement those words? I hope that this event will also try to answer some of these questions. As you know, my voice is heard almost every day, and we know why. Not because everything is rosy and wonderful in relation to these commitments, but because your governments are not valuing and honoring these commitments, almost on a daily basis. Has our group of democracies achieved progress in these 4 decades to ensure that we can speak our minds freely, without fear or repercussion? maybe our individual answers to this question would be very different. But I believe that we all agree on the fact that in the majority of the participating states, we are light years away from living in societies where these noble notions are part of people's everyday lives. Again, I would say, unfortunately. But we still call ourselves democracies. I'm pleased that we have time to debate these important issues, and I look forward to the discussion. But as your representative on freedom of the media, I can also not sugarcoat and say that everything is wonderful. It's not. And now it is my great pleasure to introduce already very dear friend, Mr. Mikhail Georg Link, the newly appointed Director of the Office for Democratic Institutions and Human Rights, who took the post on 1st of July 2014. Congratulations, and it's wonderful to have you on board. I feel stronger, and I even feel more energy to start looking into our commitments in relation to the basket that is called Human Dimension. And I'm sure I can speak on behalf of Astrid Thors, our High Commissioner on National Minorities. Mikhail, I warmly welcome you at the first meeting of this kind. I would just briefly say that you earlier served as the first Deputy Foreign Minister in the German government at the Federal Foreign Office, responsible for the OSCE, EU, Council of Europe and NATO affairs. And you were a member of Parliament between 2005 and 2013, representing the Free Democratic Party. You also acted as a member of the OSCE Parliamentary Assembly from 2006 to 2013. You studied, as I can see here, Russian, French, political science, public law, and Eastern European history at the University of Augsburg, the University of Lausanne, and Heidelberg University. I think for a start, as an introduction, that's more than enough in this very impressive CV. And before we continue with this, I would like to give you a floor with once again warmly welcome to this wonderful organization.
Thank you very much, Dunja. Excellencies, ladies and gentlemen, thank you for giving me the opportunity to speak before you on the third day in my office. I was preparing for this office since, of course, the appointment by the participating states, and I thank for the confidence put in me. I will try my very, very best to deserve the confidence put in me, and in this case, thanks, of course, well, to all of the institution of OSCE, but also to the chairmanship, of course. I'm looking forward to a very close cooperation, especially in the Human Dimension meetings, which are a landmark, of course, a landmark of OSCE ODIHR, a landmark meeting, a landmark event, the famous two-week event in September especially, but also these special Human Dimension meetings, which we have here in Vienna from time to time, and today to devote it to freedom of expression. Freedom of expression is the very, well, I would say, it's the very matrix, the indispensable condition of nearly every other form of freedom. That is a quote by the famous US Judge Cardozo back already in 1937, but I think it is still valid. It is the matrix of an indispensable condition of nearly every other form of freedom. And as Dunja noticed, of course, at various incidents, the participating states again and again have highlighted, beginning from 75, way into Copenhagen 90, Astana, of course, in 2012, Istanbul 1999, and many other occasions, the importance of our topic today, freedom of expression. The participating states have recognized the freedom of expression as a basic precondition, not only for the progress and development of every man and woman, but our societies at large. On fundamental importance, therefore, is that this right cannot be limited to only those opinions favorably received or uncontroversial. It must therefore also include those that offend, shock, or even disturb states, governments, parliaments, or any sector of the population. So critical opinion has the same right as positive opinion, without the right to offend or to be offended, as Salman Rushdie once pondered, what is the value of freedom of expression? Ladies and gentlemen, freedom of expression has, of course, a particular significance in the context of democratic elections and the right to political participation. And if you allow me, of course, elections are especially at one of the core topics of attention of ODIHR. Democratic elections are not possible where a legal framework or practice limit or inhibit campaign speech and expression. They are also not possible if there is limited access to information for voters to make an informed choice. Media therefore serve as invaluable communication channels between the contestants and voters, as they provide a platform for debates among candidates, allow contestants to communicate their messages to the electorate, report on campaign developments, inform, of course, about how to exercise the right to vote, how to monitor the electoral process, and to report on the results of elections. All this, of course, must be guaranteed. All this, of course, is a long, long way to go. In recognition of the important role played by the media in electoral processes, ODIHR was specifically tasked at the 1994 Budapest Summit to, I quote, assess the conditions for the free and independent functioning of the media, end of quote. In implementing this mandate, the ODIHR regularly carries out comprehensive, quantitative and qualitative monitoring of relevant media and reports on the media environment and the coverage of electoral campaigns. ODIHR reports to date indicate that the participating states comply to varying degrees with their media-related OSCE election commitments. An overly restrictive legal framework, which does not allow for sufficient editorial freedom, has been observed in some participating states. Insufficient legal safeguards for freedom of expression and criminalization or defamation allows for undue restrictions on media freedom in several states. Other problems relate to non-compliance with equal treatment and access requirements. This frequently includes lack of balanced reporting on electoral contestants or a disproportionate focus on incumbents. Such shortcomings require continuous attention and improvement. Ladies and gentlemen, too often, way too often, human rights defenders or journalists who disclose misconduct and abuse, express opinions perceived as controversial, or challenge majority views, face verbal attacks and intimidation. Some even face physical violence by state or non-state actors, including from violent extremists and organized crime groups. Since 2008, ODIHR has witnessed a shrinking space in many states for fundamental freedoms related to freedom of expression, such as the right to peaceful assembly and association. Restrictive legislation, increased scrutiny, and branding of NGOs as so-called foreign agents on the basis of the sources of funding have led to a chilling effect on civil society as a whole in several states. In the area of human rights, threats by many governments towards human rights defenders continue. With regard to democratic governance, there is a growing disengagement of citizens from representative politics in both the so-called established and so-called new democracies. Younger generations tend to favor new technologies, alternative and new forms of political participation, including online social movements and networks. States should acknowledge and embrace the potential new technologies have to remedy some of the challenges posed by traditional mechanisms for the freedom of expression and political engagement. However, it is important to keep in mind that all the fundamental principles of democracy need to be equally respected, both on and offline, as has been already mentioned. ODIHR has also observed a concerning trend and rise of anti-Roma rhetoric over the last years. And as you know, this is, of course, also at the very center of the attention of ODIHR and a very disturbing fact. This trend seems to especially become intensified during national and local electoral campaigns or during socio-economic crisis. The The 2013 ODIHR status report findings show that certain political parties in some states have scapegoated Roma to capitalize on anti-Roma sentiment among majority communities. These parties exploit a racist rhetoric labeling Roma and Sinti as socially inadaptable or stigmatizing them as mere gypsy criminals. Not only those representing Roma and Sinti, but civil society groups and organizations from all across the OSCE region are reporting a significant and in some places increasing number of hate speech incidents. Such incidents perpetuate stereotypes, create divisions, and generate an atmosphere of intolerance and insecurity in societies. The internet and social media are increasingly becoming major platforms for spreading hate speech. Racial slurs and offensive gestures continue to permeate public discourse. Such instances are particularly observed during peaceful assemblies linked to religious holidays, Holocaust Remembrance Days, LGBTI pride marches, to mention but a few. Civil society reports also note that statements of public figures, including politicians, present a worrying source of hate speech. Ladies and gentlemen, freedom of expression is essential to foster dialogue in which pluralistic societies can flourish, and diversity is not only respected but celebrated. In the OSCE region, however, we often see a delicate dilemma being posed between freedom of expression on the one side and hate speech on the other side. Incitement to discrimination, promotion of racial superiority, scapegoating, and verbal harassments are undoubtedly corollaries of freedom of expression. These phenomena need to be addressed and dealt with expeditiously and comprehensively. Furthermore, hate speech has the potential to fuel racist, xenophobic, anti-Semitic violence and other bias-motivated crime, also known as hate crime. Of course, hate speech and hate crimes should, however, not be confused. I don't have the time now to elaborate more about the differences, but here we have to pay attention extremely and really to work on these areas to fight both hate crime and hate speech. Ladies and gentlemen, coming to the end, as recognized in several ministerial council decisions, Dunja was talking about that, public figures play an important role in sending out a message that such divisive speech has no place in democratic and pluralistic societies. In this regard, I recall that the OSCE participating states agreed to seek, quote, opportunities to cooperate and thereby address the increasing use of the internet to advocate views constituting an incitement to bias-motivated violence, including hate crimes, and, in so doing, to reduce the harm caused by the dissemination of such material, while ensuring that any relevant measures taken are in line with OSCE commitments, in particular with regard to freedom of expression, end of quote. Considering the key importance of freedom as one of the preconditions for functioning democracy, genuine and effective exercise of this freedom does not depend merely on the state's duty not to interfere. It also requires positive measures of protection. OSCE participating states have committed themselves not only to refrain from acts intended to silence or intimidate human rights defenders or journalists, but also to actively protect them from any such acts by non-state actors. Without effective protection, I underline, and full enjoyment of the right to seek and impart information, there can be no independent human rights monitoring or reporting. Ladies and gentlemen, I mentioned in the beginning that the freedom of expression underpins most freedoms. Freedom of expression, therefore, also underpins most of ODIHR's work in close cooperation with Dunja's office, with the High Representative for the Freedom of the Media. Here, not only here, but also here, we should work and will work hand in glove. As the principal institution mandated by the OSCE participating states, ODIHR is tasked along with other OSCE institutions to support OSCE member states in meeting their human dimension commitments. The challenge lies in eliciting and promoting mutual trust and shared sense of purpose among OSCE participating states on the basis of common commitments. Often the necessary political will is lacking on the part of the one side to request ODIHR expertise. ODIHR has the expertise and offers it. It offers it as a way of trust, not of lecturing anybody, but of working for the commitments we all together have decided. ODIHR provides assistance and forums for the exchange of experiences and good practices to OSCE participating states in guaranteeing freedom of expression. That is what ODIHR was mandated to do. The annual Human Dimension Implementation Meetings and other events, I mentioned it, are these useful forums for that and these landmark events. And allow me to say that in the very end, of course, I would like in my personal work to continue where my predecessor, Janez Lenarčič, did end. In the last days, and that shall be the bridge also to our next speakers, in the last days in office, he agreed in a new cooperation agreement, he signed a new cooperation agreement with the High Commissioner on Human Rights of the United Nations. I think that is a perfect sign where the work, in which direction the work should be continued. And this continuity, of course, is what I try to achieve together with you to further develop also, of course, what we can do in either area of the 5 areas of ODIHR to really strengthen the implementation of the commitments in all our participating states. Thank you very much for the attention and looking forward to a very, very good cooperation. Hope to see most or all of you in Warsaw in September. Thank you.
Thank you very much, Mikhail. Thank you for a very strong message in defense of freedom of expression at the very beginning of your mandate, and also for mentioning our dear colleague, your predecessor, Janez Lenarčič. I'm sure that cooperation will continue and we will be serving a permanent council with our expertise together, but also separately in defense of all these rights that we value so much for our societies and in our societies. Now I would like to give a floor to a person we at the OSCE know really well, but for our distinguished guests, I think it's important to say a few information about Ambassador Thomas Greminger, Chairperson of the OSCE Permanent Council. Dr. Thomas Greminger is Ambassador and Permanent Representative of Switzerland to the Organization for Security and Cooperation in Europe, the UN and other international organizations in Vienna since 2010. From the beginning of 2014, we have the honor to have him as a chair of the OSCE Permanent Council during Switzerland's chairmanship. During his long career, he held various leading positions in the areas of conflict management, human rights, humanitarian policy, and migration policy at the Federal Department of Foreign Affairs. As I already said, now we have the honor to have him as a chairperson of the Permanent Council. Thomas, the floor is yours.
Thank you, Dunja. High Commissioner, Excellencies, ladies and gentlemen, let me start with a quote. Everyone will have the right to freedom of expression. The exercise of this right may be subject only to such restrictions as are prescribed by law and are consistent with international standards. End of quote. This is what participating states committed themselves to in 1990 in Copenhagen. The right to freedom of expression is essentially a right which should be promoted to the maximum extent possible, given its critical role in democracy. Freedom of expression and freedom of the media are indispensable components of true democracy. As Frank LaRue, the Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, told us just a few weeks ago in the Human Dimension Committee, these freedoms are essential to the fulfillment of other human rights, such as freedom of assembly and association, freedom of religion or belief, the right to vote, and many others. Having the possibility of openly discussing sensitive questions, expressing critical views, or raising uncomfortable issues for ruling political parties are fundamental aspects of freedom of expression. And this is what distinguishes a pluralistic, democratic society from a totalitarian or dictatorial regime. The OSCE representative on the freedom of the media, Dunja, Mijatović, constantly reminds participating states that the right to express opinions is a universal and basic human right that must be upheld and protected. It can only be restricted at instances of intentional and dangerous incitement to violence. The exercise of the freedom of expression carries duties and responsibilities. The enjoyment of these rights may be subject to formalities, conditions, or restrictions. Every participating state, including my own, is regularly confronted with the question of the violation and/or limitation to freedom of expression for the protection of other human rights. The question of rights and responsibilities related to the freedom of expression has divided OSCE participating states in the discussions conducted until today. Despite extensive debates, we are still confronted with a lot of questions. And this is why the Swiss OSCE chairmanship has proposed to put this topic on the agenda of the OSCE official Human Dimension events again, 24 years after Copenhagen. I would just like to raise 5 questions that illustrate the complexity of the implementation of this commitment I cited, taken in Copenhagen. First, how do privacy criteria and defamation impact on the freedom of expression? 2, is the need to fight terrorism a valid ground for states to restrict the freedom of expression? 3, should a provocative speech against universal democratic values be banned by the authorities? 4, is the notion of public order a legitimate basis to restrict freedom of expression in a democratic society? 5, what is the right balance between freedom of expression and other human rights? The OSCE Human Dimension commitments offer a relevant framework for the promotion and protection of the freedom of expression. OSCE executive structures have been mandated by participating states to assist them in implementing their commitments. As a result, not only the representative on freedom of the media and ODIHR are active in this domain, but also the OSCE field missions. No later than 3 weeks ago, the OSCE mission in Kosovo held a one-day regional conference on taking action against hate speech without violating the freedom of expression. Such activities are not limited to the OSCE. The United Nations Human Rights System and the European Court of Human Rights regularly examine this very topical issue. Therefore, I'm particularly happy to have High Commissioner Pillay and also Luis Lopez Guerra, judge at the European Court of Human Rights, here with us. They are going to share their experiences with us. Switzerland is committed to promoting and advancing democracy both in Europe and beyond. Freedom of media and expression is an indispensable component and condition of true democracy. The very fundamental need and right of people to participate in democratic processes with all their political, economic, social and cultural components must not be impaired or suppressed. Again, the OSCE representative on the freedom of media reminds us that every case of intimidation or harassment of journalists influences the enjoyment of the right to freedom of expression by others. The right of journalists to carry out their work under safe conditions without fear of being harassed, threatened or attacked is a requirement of paramount importance for ensuring the freedom of media and of expression to which states are committed. Unfortunately, the reality is different. These days, more and more journalists are threatened, arbitrarily taken to court, detained or forced to leave their country. The security and safety of journalists is an indicator of the existence of free media reflecting the full range of opinions in a country. And this is a necessary ingredient of any true democracy. To this end, it is essential to ensure that judicial systems are independent of political or other pressures. States must be held accountable to take all the measures required. Switzerland will continue to take action in this area and is prepared to make its contribution to the overall aim. The aim of committing governments in the OSCE region to establish an environment where free speech and its agents, in particular journalists, are effectively protected. Freedom of expression will remain nothing but an empty promise as long as journalists continue to be harassed because of their work. The principle of no more impunity must therefore be at the center of our response. Our goal must be to commit governments and to encourage law enforcement agencies and legislators to raise awareness, take preventive measures, and to effectively counter impunity of perpetrators. Another point that I would like to raise is the role of the so-called new media with respect to freedom of expression. The free circulation of ideas and opinions on the internet cannot be achieved as long as states try to impose inappropriate limits or controls on access. Freedom of expression in the digital age confronts us with complex issues and important dilemmas. However, we can build on a solid basis of international human rights law and on equally solid OSCE commitments. These hard and soft norms remain valid. There should be no difference in people's rights and fundamental freedoms between the online and the offline world. The same rules and principles based on the rule of law should be applied. Switzerland has continuously reaffirmed that any regulation has to first and foremost protect and respect media freedom, and any restrictions thereto have to respect the provisions of paragraph 2 of Article 10 of the European Convention on Human Rights and Article 19 of the International Covenant on Civil and Political Rights. The limits of the right to freedom of expression should not be defined by arbitrary decisions of governments, but by the people themselves in a democratic process respecting international obligations and commitments. Ladies and gentlemen, the overall objective of the Swiss OSCE Chairmanship in holding this event today and tomorrow is to strengthen the implementation of human dimension commitments, to support the activities of the OSCE institutions and its field operations, and to enable them to further develop activities to promote freedom of expression. We call on all participating states to work closely with the OSCE institutions with the aim to contribute to relevant policy development to the exercise of freedom of expression. The third working session tomorrow afternoon will give us some concrete ideas on the way forward. Speaking about OSCE institutions, let me warmly welcome Ambassador Link for his first appearance here in Vienna. On behalf of the Swiss OSCE Chairmanship, I would like to congratulate you on your new assignment and look forward to our very close cooperation. In conclusion, I would like to point out that the implementation of the existing international standards, rules and regulations is paramount. The member states of the UN and the Council of Europe, as well as OSCE participating states, have to honor and comply with the commitments and obligations they voluntarily signed up to. We should take advantage of the upcoming working sessions to continue the discussion on this crucial topic. And with this in mind, I wish you all a fruitful discussion. And before I hand the floor back to Dunja, I am happy to invite you all to a reception held by the Swiss OSCE Chairmanship after the first working session today at 6 p.m. Just here in the full saal. Thank you, and with this, the floor is back to you, Dunja.
Thank you very much, and particularly thank you and you and Swiss Chairmanship for keeping freedom of expressions on such a high position in your agenda and very busy schedule. It proves once again that we are far away from reaching the goals that we want to reach in relation to free expression and free media. So it's extremely important also for all of us leading institutions in human dimension basket to see that there is a clear dedication from the chairmanship and also all participating states in tackling these issues, and we have consensus for such an important event. Now I would like to bring us to a highlight of this opening session. We have very important keynote speaker. I'm extremely honored to introduce to you UN Human Rights, UN High Commissioner for Human Rights, Mrs. Navi Pillay. Many of you are very much aware of her extraordinary work and the role she has for many years now in relation to respect of human rights in our societies. and I would like to mention several issues from her curriculum vitae that is very impressive, but still there is a need to repeat some of the issues she tackled in her very important career. Ms. Pillay comes from South Africa. She was the first woman to start a law practice in her home province in 1967. Over the years, she acted as a defense attorney for anti-apartheid activists, exposing torture and helping establish key rights for prisoners on Robben Island. In 1995, after the end of apartheid, Ms. Pillay was appointed as acting judge on the South African High Court, and in the same year she was elected by the UN General Assembly to be a judge on the International Criminal Tribunal for Rwanda, where she served a total of 8 years. She played a critical role in the ICTR's groundbreaking jurisprudence on rape as genocide, as well as on issues of freedom of speech and hate propaganda. In 2003, she was appointed as a judge on the International Criminal Court in The Hague, where she served on the appeals chamber until August 2008. In South Africa, as a member of the Women's National Coalition, she contributed to the inclusion of the equality clause in the country's constitution that prohibits discrimination on grounds of race, gender, religion, and sexual orientation. She co-founded Equality Now, an international women's rights organization. It's also important to add that your work and your courage and the way you were tackling the issues in relation to human rights has been and will continue to be an inspiration for many of us fighting for rights of different kinds, particularly for people in far away, but some also fighting in not so far away countries for freedoms of all kinds and for the respect of human rights. With this, High Commissioner, I would like to give you a floor. Please.
Good afternoon, Excellencies and dear colleagues. Thank you, Dunja, for that very kind introduction. Let me first say that I do apologize I cannot stay for the rest of this session. I'm particularly sad to miss the reception thrown by the Swiss ambassador. Yeah, I miss the fun things in most parts of my life. I value this opportunity, though, to address a topic that I regard as the cornerstone of every democratic society. The freedoms of opinion and expression are intertwined together with the right of access to information. They are enabling rights, rights that empower individuals to argue for their due enjoyment of all other rights, from fair trials and free elections to decent living conditions. Conversely, obstacles to these freedoms undermine all other rights, including civil, cultural, economic, social, and political rights, and the right to development. The freedoms of opinion, expression, and information are enshrined in the Universal Declaration of Human Rights, as well as the International Covenant on Civil and Political Rights. Moreover, the Declaration on the Right and Responsibility of Individuals, Groups, and Organs of Society to promote and protect universally recognized human rights and fundamental freedoms, adopted by the General Assembly in 1998, expressly states that everyone has the right to know, seek, obtain, receive, and hold information about all human rights and fundamental freedoms, including having access to information as to how these rights and freedoms are given effect in domestic, legislative, judicial, or administrative systems. Furthermore, everyone has the right to freely disseminate views, information, and knowledge of all human rights and fundamental freedoms. Today, I thought I will discuss certain challenges that we face in ensuring freedom of expression. These are the protection of the fundamental freedoms of journalists and human rights defenders, issues related to the internet, and finally, the advocacy of national, racial, or religious hatred, insofar as it constitutes incitement to discrimination, hostility, or violence. This is particularly a controversial topic on which my office has recently helped produce a number of practical guidelines. So first, the protection of the democratic space, the media and human rights defenders. At its essence, democracy is about every person participating in decisions that affect his or her own life. Sound and sustainable governance rely on inclusive decision-making processes throughout society based on the rule of law, transparency, and the accountability of public authorities. These simply cannot be attained without adequate access to information and the right to express opinions. Combating corruption, for example, requires the adoption of procedures that allow members of the public to obtain information on the organization, functioning, and decision-making processes of administration. In every corner of the world, including the long-standing democracies, there are complex challenges associated with freedom of expression. In the past decade, we have seen many people around the world advocating for change, for social justice, for equality, accountability of the powerful, and respect for human rights. The protests in North Africa and the Middle East, as well as cities across Europe and the Americas, are prominent examples. Rather than engaging in dialogue to address the root causes, concerns of protesters, several governments have adopted measures to restrict public freedoms. They have curtailed public liberties, restricted the media and the activities of civil society, and violently repressed political protest. In a number of countries, governments have also used security policies, including counter-terrorism strategies, as a pretext to restrict public freedoms and the role of civil society. Elsewhere, the heightened political influence of religious doctrine or allegedly traditional values has led to restrictions on civil liberties and the media. This endangers pluralism and dialogue. Yet human rights defenders, whistleblowers, and civil society activists play an essential role in society, in the economy, and public administration. They bring to light issues that are vital to address in the interest of all, including governments. Individuals and groups who reveal deficiencies in systems, policies, and structures should be rewarded for their positive contribution, not punished for endangering entrenched interests. Silencing criticism is not only a violation of human rights, it is counterproductive to the goal of achieving safe, just, stable, and therefore prosperous societies. Journalists are also essential to democracy by helping to ensure transparency and accountability in the conduct of public affairs and other matters of public interest. But precisely because of this crucial role, they are frequently subject to violations of their fundamental human rights, including abduction, arbitrary detention, enforced disappearance, expulsion, harassment, killing, surveillance, search and seizure, torture, and threats. Censorship is another widespread violation that quite simply negates the meaning of a free press. Female journalists face additional risks, including being subjected to forms of sexual violence. These threats and attacks are committed by both state and non-state actors in order to silence journalists and undermine the free flow of information. Similarly, politicized appointments process for media regulatory bodies and their sometimes extensive power over content in the media can lead to censorship or to self-censorship. They have a profound impact on the ability of citizens to contribute to democratic processes by means of informed decisions. Moreover, in many countries, criminal laws against slander, libel, and defamation are used to deter reporting on issues of public interest and to silence criticism of public figures. In countries that have historically experienced serious and systematic human rights violations, access to information about past abuses can be central issue in the search to address the past and prevent a recurrence of the same acts. It may present a significant challenge for journalists as well as in the transitional justice process. It must therefore be emphasized that the overarching notion regarding freedom of expression and information in international law is that all information in the possession of the state belongs to the public. There are limited and qualified exceptions, but whenever a state imposes restrictions on the exercise of the right to freedom of expression, such restrictions must be demonstrably necessary and proportional. They must also be defined by law in terms that are accessible, concrete, clear, and unambiguous, and must be open for prompt, comprehensive, and effective judicial review. Enlarging, widening, and deepening people's participation in local, national, and global processes is the way forward to societies that are stable and just. In order to support the maintenance of a dynamic and independent press and civil society activism, and to work to strengthen rules and laws relating to freedoms of expression, association, and assembly, my office has made widening the democratic space a key focus of our work for the next 4 years. A word now on protection of the democratic space in relation to the internet. So I'm turning now to a related but very specific media. New technologies offer a variety of opportunities for journalists, activists, and institutions to expand the democratic space, but they also carry with them additional human rights challenges. The internet is an indispensable tool for people to receive and provide information, and makes it far more difficult for states to exercise control over information. But perhaps unsurprisingly, this has resulted in attempts to unduly restrict access to online internet content. This is of deep concern. As the Human Rights Council affirmed in its landmark resolution 20/8 on human rights on the internet, the right to freedom of expression and opinion of individuals should be protected and promoted in the online space in the same manner as in the offline world. Another challenge resides in the fact that since information is more accessible on the internet, it makes some people more vulnerable to attack. Human rights defenders who legitimately exercise their right to freedom of expression online continue to be arbitrarily arrested, tortured, and unjustly sentenced to imprisonment on the pretext of protecting national security or countering terrorism. Policy regarding the internet must be guided by due regard for the user's rights to access and disseminate information. There must be safeguards to ensure that any restrictions to access are neither arbitrary nor excessive. In addition, new technologies are vulnerable to mass electronic surveillance and interception by states and corporations. This threatens individual rights and inhibits the free functioning of a vibrant civil society. During upcoming sessions of the Human Rights Council and the General Assembly, my office will report on the right to privacy in the context of domestic and extraterritorial surveillance and interception of digital communications and collection of personal data. This is a first such instance of this right and surveillance being addressed by the Human Rights Council and the General Assembly. So I do invite you to watch out for our report, which will be made public shortly. A word now on incitement to hatred. Speech can be an incitement to action, in some cases very violent and hurtful action. And unlike international norms regarding genocide, torture, slavery, and crimes against humanity, the right to freedom of expression is not absolute. Article 19 of the International Covenant on Civil and Political Rights allows certain restrictions when they are necessary for respect of the rights or reputation of others or for the protection of national security, public order, or of public health or morals. In addition, Article 20 of the Covenant actually requires the prohibition of propaganda for war and, I quote, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. I recall a case over which I presided in 1998 when I was the judge on the International Criminal Tribunal for Rwanda. This was really a worst case scenario. People working at a radio station and a newspaper had quite outrightly called for massacres using very unambiguous words. More recently, we have seen examples of media outlets advocating attacks on individuals because of their sexual orientation, and a series of uproars over several forms of media criticizing people of various religions. A number of these incidents have unfortunately led to unacceptable violent reactions and deaths, including of UN personnel, I might add. It is because of cases like these, where speech can be clearly linked to wrongful action, that international law requires states to ban certain forms of expression that incite violence, hatred, and discrimination. Any action in response to such incitement to hatred must be, however, extremely careful and precise. Because, and I must again stress this point, the overarching principle is that expression should be free. So that's the norm. Although there is a need to combat discrimination and hatred, laws may not be misused by the authorities to silence critics and muzzle minorities and dissenters. There are a number of challenges here. The first is definition. Intolerance and even intense dislike of others may in some contexts be quite legitimate emotions. For example, when we criticize people who have oppressed vulnerable people. So when is the expression of hatred permissible? And when is it prohibited? How do we draw a distinction between hate speech and speech that is merely offensive? Clearly, severity and context are key factors. How likely is it that harm will occur, and how imminent is that threat? Is the speaker in a position of authority with leadership over millions, or a lone individual? Is there a long history of violence and persecution that hate speech could reignite? Another suggestion is to draw a clear line between expression targeting ideas, which is to be protected, and on the other hand, abusive expression that targets human beings, which may in some cases need to be prohibited. The UN Human Rights Committee has clarified that, I quote, "The mere fact that forms of expression are considered to be insulting to a public figure is not sufficient to justify the imposition of penalties," close quotes. Consequently, the committee has expressed concern regarding laws on issues such as lèse majesté, desecrato, disrespect for authority, disrespect for flags and symbols, defamation of the head of state, and the protection of the honor of public officials. A related challenge now arises, the notion of defamation of religion, which has risen to the fore over the past decade, with repeated challenges to various forms of speech on the grounds that they offend certain believers or belief systems. The position of the Office of the United Nations High Commissioner for Human Rights is clear. Human rights law protects individuals and groups, not belief systems. You cannot defame a religion. In fact, it should be possible to scrutinize, openly debate, and even harshly criticize religions or belief systems, doctrine, institution, and leaders, including religious ones. This is absolutely intrinsic to the right to freedom of expression. Blasphemy laws inhibit freedom of religion or belief, as well as healthy dialogue and debate, and states that still have such laws should repeal them. At the same time, hate speech that is directed against members of specific religious groups can be extremely inflammatory and likely to incite violence. In such cases, governments are obliged to intervene. In order to bring additional clarity to this discussion, my office organized a series of 5 high-level expert workshops in all regions of the world with the view to examine legislative patterns, judicial practices, and policies in the field of incitement to hatred, and to discuss how best to respond to such issues in accordance with freedom of expression. These workshops involved 3 UN Special Rapporteurs on freedom of opinion and expression, freedom of religion or belief, and racism, racial discrimination, xenophobia, and related intolerance, together with 45 experts from different cultural backgrounds and legal traditions. They culminated in an expert meeting in Rabat in October 2012 that adopted a comprehensive plan of action. The plan uses the full potential of existing international law to issue guidelines to all stakeholders, states, parliaments, and judiciary, civil society, activists, media, and regional and international organizations. In fact, one of its recommendations is to further enhance cooperation and information sharing both among various regional and cross-regional mechanisms such as the Council of Europe, the Organization for Security and Cooperation in Europe, the European Union, and others, and between these organizations and the United Nations. Along with detailed advice, the Rabat Plan of Action offers a 6-part threshold test that should be met for speech to be criminally prohibited. They include context, the speaker's standing, intent to advocate or incite, scope or extent, and imminence. It also points out that criminal sanctions related to unlawful forms of expression should be seen as last resort measures, to be applied only in strictly justifiable situations. Civil sanctions and remedies should also be considered, including financial and non-financial damages, along with the right of correction and the right of reply. But of course the Rabat Plan of Action will not alone achieve this task of constructing a solid framework for a society of diversity and tolerance in a society where old boundaries are crumbling. Can people of different backgrounds, history and religion live together and remain true to themselves without pushing others away? As globalization and migration intensify, all of us will encounter more people from other cultures or who hold very different opinions from ourselves, and it may be a very real challenge to learn to respect fully each other's beliefs and choices. So tolerance is needed, both across society and in our personal relations. This implies more than the passive enduring of ideas different from our own. Conceived more actively, tolerance is the positive and respectful effort to understand and defend another's beliefs, practices, and habits without necessarily sharing them. We must embrace and defend the rights of others to speak freely and disagree with us. Thank you very much. Thank you very much.
Thank you very much. I'll be very selfish and say that I note your remark that you missed the fun parts, but I'm really glad that we didn't miss this part in order to hear your strong and clear voice once again, defending human rights, including freedom of expression and freedom of the media worldwide. Thank you very much once again, High Commissioner. With this, I will give a floor to the Director of my office, Dr. Andrei Richter.
Thank you, Chair. Distinguished participants, please listen to some very important technical information about this meeting. The meeting will last 1.5 working days and will consist of the opening session, which is about to conclude now, 3 consecutive working sessions, and a closing plenary session as reflected in the agenda. An annotated agenda was prepared in order to set a framework for discussions and highlight the focus areas. Please note that at the opening and closing plenaries, delegations of the participating states are seated at the main plenary table. At the same time, for all working sessions, the table nameplates will be taken down and all participants can sit wherever you want, including the main table. At the opening session, no comments or statements are foreseen from the participants. At the closing plenary, only the delegations of participating states can make statements. Working sessions are intended to be based on a free-flowing discussion, and all participants can take the floor. In the interest of creating conditions for genuine debate, there will be no speakers list for the working sessions. Instead, if you would like to speak at a working session, we invite you to raise your hand to attract the moderator's attention and to wait for the moderator to give you the floor. Please introduce yourself, name and organization, delegation. If possible, please comment directly on what was said before. Please keep your comments brief and to the point. Feel free to ask questions related to the discussion. Constructive criticism is welcome. In case there is a large number of participants wishing to speak, speaking time will be limited to a maximum time defined by the moderator, and the moderators will be strict to keep it. Participants are strongly discouraged from reading out prepared statements. Prepared statements can be submitted to the document distribution center behind the door, which will make them available for all participants. If the speaking time is limited, don't try to compensate by speaking fast. Speak slowly and clearly so that the interpreters are able to interpret into other 5 OSCE languages as marked on the booth. At the end of the working sessions, as well as at the closing plenary, participating states will have a right to exercise their right to reply. Please signal to the moderator early enough before the end of the session should your delegation like to exercise this right, so sufficient time is left for it. The aim of the meeting is to produce concrete results, so please propose concrete recommendations and then elaborate on them. Also, please preferably provide your recommendations in electronic or printed form to the document distribution center so that they can be included in the HDM final report. Please note that during the course of the meeting, side events are organized and some were held already. So if you are interested in attending, please consult the schedule. Notes will be taken during the discussions. At the end of the meeting, at the closing session, moderators will summarize the result of each working session with a particular focus on recommendations. A final report will be issued by representative on freedom of the media within approximately 60 days after the close of the meeting and will be posted on the website. Thank you for your attention, and I request the chair not to announce a short break, but to continue with session 1.